This Family Life News podcast is made possible by the support of listeners like you.
This is Faith Under Fire. We take you straight to the front lines of religious battlegrounds. I'm your host, Sarah Harnisch. With me, founder and chairman of Liberty Counsel, Matt Staver. Thank you for hopping on this week, because what a week it has been for you. You presented the oral arguments to the Fourth Circuit Court of Appeals in the case Zinski versus Liberty University. Tell me more about that case.
Yeah, this is a case that Zinski intentionally set up Liberty University, taking female hormones for at least 4 months before applying to Liberty. On the application, he was presented with the very specific doctrinal statement that says God created us in his image, male and female, and that to identify as anything other than the sex God created you at birth is a sin. He ultimately had a plan to keep this quiet for the 90 days, and then after the 90-day probation to reveal this to Liberty. So after the 90 days, Zinski sent an email to Liberty HR saying that Zinski had been taking hormones for months and was having observable outward changes and wanted to let Liberty know before those became even more apparent. Liberty had no choice but to maintain faithfulness to its doctrinal position and terminate him. Zinski then filed suit against Liberty. So the real issue, I think, here is if Liberty has to set aside its doctrinal statement for thousands of different theological versions of its employees, then Liberty has no doctrinal statement. If the ACLU were to win, that means not only Liberty University, but other religious employers would have no ability to hire and maintain employment of employees consistent with their theological and doctrinal beliefs. That would mean that religious employers have literally no religious freedom whatsoever, and that cannot be the law. That's why this case is so critically important.
What happened in the courtroom this week?
It was very interesting because Judge Quattlebaum asked a question to the ACLU attorney about a church that employs 16 people. Hypothetically, if there was an employee who was transgender and they wanted to, quote, transition, and that was contrary to the church's theological belief, would the church be required to hire that employee? The ACLU responded yes. And then Judge Wynn said, wouldn't that inject the courts into managing the internal operations of a church? So I think it really raised the specter of how extreme the ACLU's position is and what their ultimate objective is, and that is to have the LGBTQ agenda always trump religious freedom, which means you would have no religious freedom.
What happens now?
Well, what happens now is the court will consider this case, make a decision. Interestingly, on that particular day that I argued the case, there were 2 other religious freedom cases back to back, so 3 altogether. Liberty's case that I argued set the standard for the entire day of oral argument, and Liberty's case was referred to frequently in the other 2 arguments. So the court will decide these 3 cases. They're all separate, all different facts, and it may take several months, after which, when the court issues its decision, if it is favorable to Liberty, which I anticipate it could well be based upon the facts and the law and the way the argument went, then the ACLU has the opportunity to ask the U.S. Supreme Court to take the case. On the other hand, if it goes against Liberty, we will certainly, without question, ask the United States Supreme Court to take the case. And Judge Wynn, who was the presiding judge during the argument, actually made a comment about how the Supreme Court has not addressed some of the critically important legal issues raised in the Liberty University case, and that it needs to be addressed, but that in the absence of the Supreme Court making a decision on these specific issues, this court will make a determination and make a ruling that likely ultimately will go to the U.S. Supreme Court. If that happens, the Supreme Court could make a decision on this sometime by the end of June of 2027.
I can't even imagine the implications of a decision against Liberty in a case like this. I mean, not just LGBTQ+, but what if someone walked in and was pro-abortion and wanted to work for a ministry, or was polygamous and wanted to work for a Christian ministry? It's far-reaching.
It's far-reaching. This case, the facts involve LGBTQ, but it's far beyond that, as you note. So, for example, if you have a crisis pregnancy center and someone begins working there and they want to subvert the crisis pregnancy center, and after the 90-day probation, they come out and say, well, you know what, I am pro-abortion. Would that crisis pregnancy center then be forced to continue to have someone who's actually speaking with, counseling, greeting people that are coming to their place that's actually pro-abortion, that's the absurd situation. And it goes beyond just that kind of issue. For example, an atheist that wants to come and join, now they broadcast that they are an open violation, open rebellion of your doctrinal position. That would make the workplace a place of chaos. And that's why you have constitutional protections like the church autonomy doctrine that applies not just to churches but to religious organizations, that government cannot micromanage, they cannot dictate some of these specific theological decisions of churches and religious organizations. You also have Title VII itself. Title VII says that if a religious organization makes a decision based on religion, as in this particular case, this was clearly a religious-based decision, then that employer has the right to do so. That's the issue here, and it's significant, not just for liberty. It's very far-reaching for every religious employer.
Why is it important for Christians to take a stand? Even when we're talking about taking a stand in the way that you do by walking into a courtroom, why is it so important that our voices are heard in these places?
Take this as an example. Say a mother and father, they want to send their child to Liberty University, and they look at the doctrinal statement, and they agree with it. I want to send my daughter, my son to that university that has these specific Christian values. But then when they actually come to campus and they see, well, that's their doctrinal statement, it's in writing, but all their employees are running around with the LGBTQ pride flag. They've got pro-abortion on their T-shirts. That would be a hypocritical situation. I'm not going to send my kid here. What this means is that you can have your faith in print, but you can't actually exercise it. And it's going beyond just Liberty University. It's going beyond an educational institution. It's going beyond a religious employer. It means that people of faith can actually live out their faith in the public sector, in the workplace, in the school environment, in the religious mission and message that you are called to advance. And if we don't have that freedom, which is the fundamental freedom that birthed America 250 years ago, then we have no freedom at all. Religious freedom is the first of our freedoms in the first 10 amendments. And if we don't have that freedom, no other freedoms really matter.
Learn more at lc.org.
Thank you for listening to this Family Life News podcast. If you've been encouraged by what you've heard, please share it with others and click the subscribe button to automatically receive future episodes. Family Life is a listener-supported ministry. Podcasts like this are made possible by your financial partnership. Find out more at familylife.org.